Board President Trujillo, we are all present and accounted for. If you'd like to start.
Sure. Okay, good afternoon, everyone. It is November 30th, 2021, and welcome to the meeting for the Board of Registered Nursing. We will take roll call to establish a quorum. I am Dolores Trujillo. I am an RN appointed by Governor Newsom in the direct care provider role. I am also the current president of the Board of Registered Nursing. Vice President Mary Fagan.
I'm appointed in the Nursing Services Administration role by the governor.
Thank you. Elizabeth Woods. Elizabeth Woods.
Elizabeth Woods. I just unmuted myself, sorry.
It's okay.
I am a family nurse practitioner. I was appointed by Governor Brown in the advanced practice role.
Thank you. Imelda Seha-Buckowitz.
Imelda Seha-Buckowitz, public member appointed by the governor, Jerry Brown.
Thank you, Imelda. Susan Naranjo.
Susan Naranjo, public member appointed by the Speaker, Rendon.
Thank you. Jovita Dominguez.
Jovita Dominguez, appointed by Governor Newsom in the educator role.
Thank you, Jovita. And our executive officer of the board, Loretta Melby.
Thank you, Board President Dolores. This is Loretta Melby, or Lori. I'm the board's executive officer appointed by the board.
Thank you. And our board counsel, Reza Bajuhish. Sorry.
Everybody, Reza Pajuhesh, BRN Legal Counsel.
Thank you. We've established a quorum. BRN moderator, can you open up for public comment for items not on the agenda after the instructions?
Perfect. Good afternoon. This is the BRN moderator. I will be moderating the meeting. To facilitate public comment, we will be utilizing the WebEx question and answer feature. When the board reaches a point in the agenda at which public comment is appropriate, the question and answer feature will be turned on and members of the public can indicate that they would like to make a comment by inserting the phrase, "I would like to make a comment," in the question box, which is typically in the lower right of your screen. I will then call on the individual and unmute their microphone. The individual will have 2 minutes to make their comments. I will not give a warning as your time approaches. I will mute your microphone and will announce that your time has exceeded the time allotted. I will then move on to the next member of the public who has a comment. Please note that the question and answer feature is being used only as a means for members of the public to represent that they would like to make a verbal comment. This is not a means to ask questions of the moderator or members of the board. Such inquiries submitted using this feature will not be answered. When asking a question, please make sure the question is directed at the host, me, in the dropdown. I will provide a brief reminder of this approach at the start of each public comment item. Finally, when board members or senior staff are not speaking, I would like to remind them to mute their microphone. If I detect background noise during the meeting as a result of unmuted microphones, I will interject with a brief friendly reminder. We will be opening for public comment now. I will be activating the question and answer feature. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Board President Trujillo, there are no public requests for comment. Would you like me to close this window?
Yes, thank you.
I got a notice that Betty was disconnected. Betty, are you still here?
Back on.
Okay.
Something
Okay. All right.
happened, but I'm here.
All right. Perfect.
Thank you.
Okay. Thank you.
Okay, moving on to item 4.0, discussion and possible action regarding the board's strategic plan for 2022 through 2025. And Lori, are you prepared to speak on this?
I am. Thank you very much. So at our previous board meeting, our board voted on the strategic plan, and it has been brought forward and worked with our team to do an action plan that now addresses that strategic plan. So the action plan is being presented today to be voted on. To be accepted is our hope, so that we can get to work on this next month and have that fully implemented. Understand that when you are reviewing the document, the items in the blue with the 1.1, those have already been voted on and passed by our board. So those are not editable. But the white under the 1.11, 1.12, etc., for each one of the action items, if you guys have something that you don't see on there that you want added, please let us know. Or if this is acceptable, please let us know. Or if there's something you want stricken from the major tasks, please let us know. But understand that the blue is has already been voted in.
This is Imelda Seja-Betquitz. I have a question. So I understand that
Yes.
the blue has already been voted on. I do have a question. So there's some that have completion days ongoing or done by quarter of, whatever certain years. I know in the past we've done strategic plans as well. However, I don't recall that we have actually gone back and see where we're at with those particular goals. So will this board, like after each quarter, go over those goals that were anticipated to be completed to see where we stand?
Yes, Imelda, at our last board meeting just a couple weeks ago, that was discussed. We finalized the previous board strategic plan, and your request was to be updated on those goals being met, the ones that were not met. And I said that we would report those out on an annual basis. And then on the new strategic plan, I mentioned that we would be doing a quarterly report out on that. So that was voted on last board meeting just a couple weeks ago, and that will be happening.
Thank you. I just wanted to be noted at this meeting as well. Thank you, Lori.
Yes, no problem. Thank you.
So Lori, maybe you can let us know what action is needed since the blue has already been voted in.
Yeah, it's just the major task. If you guys have no questions or proposed changes on the major tasks, the request would be for the board to accept the action plan to implement January 1, 2021.
Lori, this is Mary. The things that are the success measures that are in gray, are those open for discussion and revision as well?
Yes, they are. I apologize for that. Those anything other than the blue. The blue was what was voted on at the previous board meeting and accepted. So the gray can be discussed within here as well. And then if there are a lot of revisions that need to be done, we can always ask that the motion to include that any non-substantive changes can be finalized through the admin committee prior to implementation in January. And that would give yourself, Mary, and Dolores final okay. And that's what's been done in the past, as well as for Sunset, which is the next agenda item.
One of the success measures that I would hopefully like us to be a little more aggressive with is under enforcement. For 2.1 to reduce enforcement processing times. And the success measure that is indicated now is the 540-day goal has been met, reducing the time to process cases. So that makes me, that success measure sounds to me as if there really isn't a goal there to improve.
Yeah, so the success measure would be that the 540-day goal has been met. It has not been met for us. And that is a DCA-wide enforcement goal. So that's what that 540 days is.
And I would really like to see us be more aggressive than a 540-day goal when we are concerned that we have nurses practicing that are not safe to practice. I don't know what some of the goals that have been able to be achieved by any of the other boards. Are there boards that are best practice that have been able to do things differently in order to improve this process?
There are, and to speak frankly, a lot of the boards are not able to meet the 540 goal. That is a process that is looking at being improved by many, and actually, the 540-day goal is actually being evaluated as if it is obtainable. What we need to take into consideration is this is a general process. It's not specific, and so there are times that are out of our control. If we're working with the Attorney General's office, that's out of our control. If we're working with DOI, the time with that's out of our control. And a lot of these do end up in the court system. And so there's timing with that has to be laid out. And Reza, you might actually be able to help additionally explain some of these processes too, because there are legal timelines. So we can do our part with the BRN timeline, and we can do our part with specific processes that we have control over, but it ultimately goes and kind of settles with Attorney General's office, DOI, and as well as our court systems.
Is it possible to break out those, the cases that are within the BRN control and hold ourselves to a higher standard for those?
We can. That would have to take much more in-depth of evaluation and would not be part of this specific strategic plan. That would go in to be a complete deep dive into our enforcement process, and to let you know that is something that we have initiated. We have the Office of Organizational Improvement Office that we're putting a charter together right now to go in and look at streamlining and doing kind of a leaning of our enforcement process. And that's already been started. And that is separate from our strategic plan. The strategic planning with the 540-day, that is an overarching goal with all DCA boards and bureaus. The enforcement goal that's an established goal. So if we meet that, we've met this goal, but that does not stop us or hinder us at all from doing specific enforcement improvements. And we've already kind of chartered that, and we will be moving forward on that on our own separate from this.
Is this something that the Enlighten process, which has helped with some of the improving processes, would be involved with enforcement as well, or is it just licensing right now?
Right now it's the Enlightened License Project, and it's being involved with that. However, when we did receive the reports in June of last year, I started a kind of an auditing process within our enforcement through DCA, and got it approved by agency to make sure that we were doing some of the efficiencies and continuing with some of the performance measures that were brought forth with the 26 recommendations from the 2016 audit, which were all based on timeline and efficiencies in enforcement. So under that, the process was evaluated that we are still meeting the majority of those, and some of the ones that we were not meeting, that was just because process had changed, and that's no longer a goal. But during that process, we also identified some further efficiencies, which is why we went ahead and contracted with the Office of, Performance Improvement, and I'm just blanking on the name. It's OIO is what we call it, Organizational Improvement Office. Sorry, thank you for your patience with that. And so based on that, they're going to do a deep dive into our enforcement. They're going to look at all of those processes, and we will identify more efficiencies that could be done. I hear your plea, and I'm stepping up to answer that. That is a focus of us as well.
Then my question is, do we want to put something in the strategic plan to be more specific about that? Because I really think that would be important.
I hear you on that. I don't think that it's ready for this strategic plan. I think that we need to get more into what the charter is, where everything is defined, and I can report that out separately. But I don't know that that needs to be in this specific strategic plan because we are still in the developmental phases of that charter.
I think that I'm just having a problem where it says has been met. Maybe just rewording that. It appears that we've already accomplished it. I don't know. We could just put the 540-day goal, reducing the time to process cases. I don't know about you guys, but I just think that has been met is kind of misleading.
Yeah, we can look at wordsmithing that, making it a little more clear. And Reza, did you want to chime in more on the enforcement process and timelines? Is that something that you have more information to add to it? I know I probably didn't do it justice with all of the intricacies that are involved with that.
I think you did a pretty good job. I don't have a ton to add, but I will say, kind of seconding some of what you said, that for one thing, the 540-day figure is, if I'm not mistaken, I believe that came from the Consumer Protection Enforcement Initiative, the CPEI. I could be wrong about that, but I know that the 540-day target is it's a general target that, you know, it's not just a BRN thing, it's across the boards that are trying to meet that, and many do kind of struggle with meeting that. Legally, the reason I don't have a ton to add is that there's not anything in the law that says we need to process cases faster or slower. We don't deal with, for example, statutes of limitations in administrative discipline cases. Of course, one of the factors that our board considers when looking at a discipline case is the amount of time that's elapsed since the incident that gave rise to the cause for discipline. And of course, the more time that's gone by, presumably the more time the individual will have had to have been rehabilitated, and et cetera. So that's always a factor, and it's always preferable. Absolutely, I'm 100% with you, Mary. Always preferable to get these cases sooner and be able to, if there is action warranted against the license, to take that action sooner than later to protect the public. The process, though, part of why it often is a struggle to meet that 540-day timeline or something shorter than that. It as with, not just administrative law, but the law in general, it takes quite a bit of time to put together a case, including gathering documents, talking to witnesses, scheduling, those interviews, bringing in the necessary experts who need to review the evidence and documents and then take time themselves to put together an expert opinion. All of that happens at the investigative stage, and then it goes through either BRN's investigators or the Attorney General's office, depending on what type of case it is, which then it takes time to actually write an accusation or a statement of information. It takes quite a bit of time, and that's, again, I'll say it again, I'm totally in agreement that the quicker we can process these cases, the better. And the only kind of hesitation I have, and this is just kind of based on general observation, not just with having worked with this board, but other boards in the past, and a general observation is imposing a a time limit like 540 days or whatever it may be, I mean, that amount of time it's good to have a target. It does kind of, light a fire under folks and get them, keeps their eye on the ball. But nevertheless, it is, for lack of a better word, kind of arbitrary. And there are some cases that it's no problem getting them processed within that amount of time or much less. On the other hand, there are cases that do warrant more time. And when you have kind of an arbitrary cap on the amount of time, it puts pressure on people to hit that target regardless of any other consequence, because you have an immediate consequence of not meeting the target. Well, the consequence that's not really seen is corners that might be cut in terms of, properly and fully building the case and doing the due diligence and really thoroughly investigating the matter. Those are the kinds of things that are kind of the downside of having a kind of an arbitrarily set cap. So, that's not to say that we shouldn't have a figure like 540 days or even a lesser amount of time or whatever amount of time that folks think is appropriate. But it is just something to kind of keep in mind. And so if you were to, the 540-day figure, as I said, is not self-imposed. That's part of a bigger, broader initiative. And obviously absolutely continue to strive to meet that and go beyond that by trying to do better. I think, you could talk about imposing a tighter timeline in terms of a stricter number of days, or just, the enforcement team, trying to continue to do what they're doing and buckling down and processing cases expeditiously. Which is kind of more of a management issue, not a legal issue. And it's separate from any cap, that's set in terms of a number of days. But just the kind of general point that I wanted to make to add to what Lori said was just my feeling that it's important to give, it's absolutely critical to process these cases quickly and remove nurses from practice or get them under supervision when they are deemed to be unsafe to the public. But on the other hand, it's also important to really have the time it takes to do the due diligence and properly prepare a case so that we're not, doing them with less than the full attention and thoroughness that they deserve.
Well, I think at least for the purposes of the wording, I would want to say that, based on what Imelda said, that we would at least meet or exceed the 540-day target. With that, I mean, the other way to deal with this is to not look at the average, but to look at the median, which takes into account the outliers, and find out exactly where we are now, and then aim for a 20% improvement or whatever makes sense. Then it's something, because, as we all know in quality improvement work, you need to have a SMART goal, right? It needs to be time-based, it needs to be achievable, right? And just putting some random, like we want to improve, and then it's hard to hold ourselves accountable and say, did we really do what we said we were going to do?
So do you have a suggestion on how you would like to rewrite this success measure for 2.1?
Do we have the median information, Lori?
I have messaged our enforcement chief, Shannon Johnson, and I have not received a message back from her yet.
And my suggestion would be either, and I'd use that, say, meet or exceed the 540-day requirement, since that's what's in statute, but preferably to me, it would be something that's more specific to where we are now, looking at the median, taking those outliers into account, and then aiming for, a lot of times in improvement work that I'm familiar with, we try to aim for like a 20% improvement, especially because we definitely have room to improve. I don't know if that's achievable or not, but something.
We do have room to improve, and I did just get a response back from Shannon, and she says they complete 55% within 540 days. She's also in our attendees right now. So board moderator, if you would like to elevate Shannon Johnson so that she can be part of this discussion and jump in and with the information that she has that's pertinent to this. Thank you. I see that she's been elevated. Shannon, are you able to unmute yourself?
I'm here.
Thank you.
So over the years, we have made efficiencies, and this number has decreased in our case time completion. So years ago, we were up, I believe, over 1,000 days for a case, and we've dropped it quite a bit over the years in trying to implement new things. One of the items is our fast track cases. We implemented that with the AG's office. So all of our paper cases, which are the arrest convictions and the out-of-state disciplines, they have a group of attorneys that those go to so they can move them along quicker, because we don't have the large investigative case with all of the medical records and all of that. So those cases, we were able to decrease that number of ours with using the fast track, and we're continually looking at ways to improve. But the two large portions of time for those cases are, one, on average, the AG's office is about a year. On average, Division of Investigation is about a year. So if you look at cases that are going through DFI and then to the AG's office, you're already at over 700 days for a case, not to mention the time at expert, the time at the complaint intake desk when they're having to obtain records. And then the processing time for our legal desk, the processing time for the board to review and vote. So you take into account all of that. And so that's why we started looking at, okay, well, if we're not meeting the 540 days, what are we doing? Where are our cases? And so that's why we split them out like that. So we can show that at least 55% we are meeting the 540. And we just continue to look at ways that we could, chip away little bits of time, because everything adds up. So that's where we are right now. And I would like, my goal, I would like to have more cases, 60, 65% that are done and completed within the 540 days. In honesty, and we've had conversations with other boards, the 540 days is very, very difficult to attain.
Thank you, Shannon. Just to jump in and kind of add more to that, there's a couple different things, and Shannon, it might be helpful for you to kind of elaborate on it, because I know it really helped me when you explained that process to me, is the PC-23 process, the interim suspension order, ISOs, and how when we get a complaint, we acknowledge and within 10 days, and we kind of go through that process. And so then that way, when we get something that is a criminal case that has gone through there, we know that we can take action immediately and suspend or remove license. And so if you can kind of talk about that legal process, so that even though it does say 540 days, that if it's an egregious thing or something like that, we do have the ability to move on that, Shannon.
Yeah, so I that's a huge concern when people see the 540 days. But when we do, say for instance, when we receive a rap sheet, so if a nurse is arrested, we receive the rap sheet the very next morning. If it is an egregious case, lewd and lascivious acts, anything with involving a child or the elderly, murder, some cases that we do get, because they were arrested, we, under Penal Code 23, we have the authority to go in, or have the Attorney General's office go in and represent us in that criminal proceeding and request that the license be suspended or have conditions placed on it through the criminal proceedings, which then gives us time to prepare our administrative case. However, a lot of the criminal judges at times, which, it's hard to believe, but some of these, they actually reject, and they do not order that PC-23 suspension on the license. Therefore, that nurse then is allowed to continue to practice. However, if we do have all of our evidence intact, and ready to go, we can go to the administrative court and request an interim suspension order based on our administrative case. We don't do those very often because of the fact that we do have to have all of the evidence together. And if there has not been a conviction and we're still at a place where all we have is an allegation that we cannot prove, then we cannot move forward with the interim suspension order. So they're very tricky to obtain the interim suspension order. Now, if we have been involved in an investigation and we have all of our evidence together and we feel that it's a felony criminal case, or, you know, we'll refer it to the DA's office as well. And we will pursue the interim suspension order at the same time. So we do have other avenues for those egregious cases. When we say the 540 days, those are usually, and I don't want to say our normal cases because not, you know, these cases are not normal, but the norm of what we see. The egregious cases follow a different route.
Does that help to answer the questions and kind of clarify some of the concern with the 540-day goal? I can provide more information. When we were going through these major tasks and looking at the success measure, looking at the major tasks, responsible party and completion dates, it was done as a complete executive team. And with the complete executive team, that it did include myself, Yvonne Leonard Taps, my assistant executive officer, as well as chief of licensing, the deputy chief of licensing, the deputy chief of board operations, chief of enforcement, our special invest. I'm sorry, I'm butchering Scarlett's title. Shannon, sorry. My head's a little foggy here. I'm not feeling
Deputy Chief of Investigations.
Deputy Chief of Investigations, Scarlett Treviso. The nursing education consultants and supervisors were on as well. And so these were definitely a team process, and enforcement and investigations with their direct line reports all came together to make these tasks, responsible parties, and completion goals.
Then I guess my request for rewording would just be to say to either meet or exceed the goal. It's because it really does sound like we've already accomplished it, the way that it's worded.
Yeah, we can wordsmith the success measure for 2.1, and then as part of the motion, if you guys wanted to make the motion, you could state that you would give the administrative committee the final approval for publishing and movement on this. So we can go through and make any of the amendments that you guys are suggesting here. We'll turn that back around, and the board president and vice president would be able to vote and finalize that.
You know, are we done on this particular subject, or does anybody else have anything else to say? 2.1. Looking at 1.8.3, I would just like to make a suggestion that in looking at the pros and cons from other states regarding the compact, that we look at also discipline and enforcement of that discipline, the CE requirements that the particular nurse has from whatever state she's coming from, and also the training. So just in addition on the pros and cons, that's it.
Okay, we excuse me, we can absolutely do that. Again, I don't know that it needs to be written as part of the strategic plan here, but when we do the report with the pros and the cons and evaluate the benefit and drawbacks, I'm sure that those will be mentioned in there, and I will track that to ensure that that is done as well. But again, I don't know that we need to modify the strategic plan to call those out specifically. And then, but I will ensure that those are included as part of the either pro or the cons, whatever the reporting comes back as.
All right, thank you.
You're welcome.
That was the only suggestion that I had. Does anybody else have any other questions? Comments?
Just there are a number of the ones under continuing education have as the success measures complete audits per comprehensive plan for approving and disapproving continuing education opportunities. It's not familiar what the comprehensive plan is.
What number are you on?
I
Mary?
can clarify that for you, Mary. On our board's website, under the quick hits, under school reports, it says other surveys and reports. And if you're to click on that, there are, I'm sorry, that is actually not where it's located. I apologize for that. There was in one of our previous sunset, a request from the legislators to do a comprehensive plan for approving and disproving continuing education opportunities. And we had to turn that into the legislators, one in January of 2019 and a second report in January of 2020. As I'm sure everybody is aware, after that second report was turned in January 2020, both BRN executive leadership switched and changed, as well as the pandemic hit. So it has been very, very difficult to get the continuing education unit up and running. That was put forth in a BCP as part of this plan to allow for all of these improvements to be completed. One of the most difficult positions at our board to recruit and retain are nursing education consultants. That unit was built with a supervising nursing education consultant as well as a nursing education consultant. Right now, we do not have a supervising NEC in that unit, and the NEC that is working in that unit, approving the continuing education providers, is myself. I've been filling in for that role for over a year now, while we work hard to recruit and hire in that position. So I am doing all of those processes. So until we are able to hire into that unit and get that up and running, we have not been able to carry out the majority of what's in that comprehensive plan. Our goal is to 100% carry out that comprehensive plan. I'm in need of staff right now in our NECs. We have, I believe, 9 vacant positions. That has been brought up in our sunset report last year, again in the follow-up report from last year, and is in the report for this year. It is very difficult to hire in anybody because the pay rate is exceptionally low for an RN. And so I have 3 people in the hiring process right now for NECs. I have offered them a job and they have denied it based on pay. So we're back in the HR process trying to get a hiring above minimum. The pay rate for a nursing education to come into state service and work with this is absolutely identical to that of a new grad. A nursing education consultant, our board is required to have experience, advanced education, experience within academia, and be able to work side by side with our deans and directors that are doctorally prepared. That will not happen with a new grad. And so that is a very, very difficult position to get hired into. And so I'm having no luck at this point getting that out. I have talked with my executive staff just this week on what we can do to get more awareness out there. So we are putting together the list of the 9 NEC positions, including 2 supervising NECs, and we will be putting that out on our listserv. We will also be putting it out with social media, and we will be sending it out to COADN and CACN, our nursing program directors, out to the deans and directors, and just really kind of opening up our search That is a statewide position. They are 100% at home with home offices. They do not report to our office at all in Sacramento, and they do work completely remote and have been very successful doing that for years. So with that is a benefit and seems to be very one of the things that allows for people to come into this position. Again, we are looking at redoing the CEU unit so that maybe it would not be required to have a supervising NEC in that unit, that we can get another type of a supervisor in that unit that would work just as effectively in that role to oversee. So there are a lot of different things that we're looking at, trying to get that done, but it does go back to this comprehensive plan. And what I can do, Mary, is I can send both of these plans to you in email for you to review. They are located on our website. They are a public document, and they have been with the legislator in both 2019 and 2020. At the beginning of each one of those years, those were submitted as required. And so now we just have to have a plan to get that going. And that's what the focus of this strategic plan was. My ask was to get us into compliance with that, to stand with our word and make sure that we're doing what we've promised everybody that we will do. Yes.
So I'm looking through all the other proposals. Is there something about looking into the well, working remotely? I'm lost of words right now. Sorry. Gosh, I'm sorry. When you work, when you don't have to go to the office, but you're doing at
like
Telework.
teleworking.
Teleworking.
Yes.
I'm thinking about a lot of the, everything's on Zoom now.
It is.
But also the clinical, help me out.
Telemedicine or telehealth.
The waiver where they don't have to go in clinicals because of COVID. And so
okay. So yeah, I could talk a little bit about that, and that's not on the strategic plan because that comes down to regulations and statute. We have a waiver right now through the Department of Consumer Affairs brought on by the executive order that allows for 50% in not in direct patient care. So 50% has to be in direct patient care. Simulation. So with simulation, we need to understand that our regulations do not talk about simulation, and neither do our statutes. Our regulations only talk about direct patient care. So we regulate the direct patient care aspect. So what we do right now is we have 50% under the DCA waiver of direct patient care requirement for med-surg, OB, peds, psych mental health, and geriatrics. That waiver right now is scheduled to expire 12/31 of 2021. So we have about another month on that. Additionally, what we have is with the passing of AB 2288 is actually in our business and professions codes now, and that's 2786.3. And that was extended with the last sunset just this few months ago. And that is allowing the schools to use that provision for the 50% in med-surg and geri and down to 25% in OB, peds, and psych mental health, with an additional 25% being in telemedicine for their clinical experiences to be counted as direct patient care. And that right now goes through the academic term of 2022, and that will then expire for use currently in June of 2022. But the schools are able to utilize that right now as well. Does that help?
So I understand. Yeah, I understand we have to go through legislation to do the simulation. But can we kind of put something there, explore the possibilities of, continuing simulation, more the online courses I understand it has to go through legislation, but if we put it on here, it would be,
a couple different,
explore the possibilities.
Yeah, so a couple different things with that, Imelda, is we did have a board agenda item just last meeting 2 weeks ago. And we opened up that and we assigned that to the NEWAC committee. And what we discovered on that investigation when looking at our regulations is that we can't, there's no 50% anymore. It's a 50% of what? So we had that discussion about establishing a baseline for direct patient care, because without a baseline, we cannot do a percentage effectively. And so what is required right now is 18 units in a semester units, 18 units for licensure in all 5 of the content areas. And the schools have an individual curriculum that is approved for each one. So there's no standard curriculum. And so there are some schools that will do 3-unit clinical, and that 3-unit clinical is 144 hours. And so 50% of a 3-unit clinical is.
So Laurie, I'm sorry, I'm going to interrupt you, but
yeah, absolutely.
I understand all that. I'm just saying for a strategic plan, if it's not in a strategic plan, it's like, I know we talked about it the last meeting, but if it's in our strategic plan, it's there, and we at least are going to explore the possibilities. That's all I'm saying. If it's not there, we might not look at it again, even though we did say we were going to explore, but I would just like it on the strategic plan, so we don't forget about it and continue to go back and forth. That's all I'm saying is I just thought maybe it should be included in our strategic plan that we are going to explore. Reza has something to say.
Yeah.
Thank you, Imelda. I just wanted to clarify the section that Lori mentioned that resulted from AB 2288. That's Business Professions Code Section 2786.3. That's not going away. Technically, it's essentially it was effective until the end of the 2021 academic year, and whenever the governor declares a state of emergency that essentially makes a clinical facility unavailable due to the state of emergency. The wording in the intro of section 2786.3, it's a little bit more technical than what I just said, but that's essentially what it is. So that's on the books. It's not going away.
Yes.
And it allows for kind of deviation from our usual clinical training requirements whenever there is a governor declared state of emergency that impacts the availability of a clinical site.
And it doesn't have to be statewide. It can be county specific. And so right now we have a statewide declared emergency, which is all the schools get to participate in that and utilize that. But with the ongoing effect of 2786.3 is it can be used county specific. So wherever there's a county that the governor does a state of emergency in, and it affects clinicals within that. And then real quick, Imelda, just to point you to section 4.4, and we have a specific entire area on there that addresses this. And so 4.4, it says evaluate the minimum educational requirements for direct patient care based on evidence to determine the benefits and drawbacks of decreasing the direct patient care requirement. The success measure is 16 CCR 1426, which is our regulation that defines the clinical direct care component, is current and is evidence-based to ensure preparation of the applicant to meet the mission of the board. We have on there in 4.41 to update regulations to review the study outcome from NCSBN, to present the outcomes to the board, to receive stakeholder input, and to engage the deans and directors. So you have an entire initiative in the strategic plan 4.4 that is specifically set up to answer the question that you're asking for.
Okay, that's all I want to. That's so. I just want to make sure that it's on there, and if you're saying that,
it is. Yeah, absolutely. It's 4.4
addresses that. That's all. Thank you.
It does. I think just the education part that we need to keep putting out to our stakeholders is that we don't have a regulation that talks about simulation. We have a regulation that talks about direct patient care. So by decreasing the direct patient care or setting a minimum standard for direct patient care that will then allow the schools to do what they need to do with the simulation. And so it would not put a cap on that simulation. And so that's the direction that we're working with within our defined regulations. Okay, Milda?
Because it is addressed, if you're saying it's going to be addressed in that section, that I'm good with that. I just didn't
that's
see,
where
I just didn't see it, spelled out simulation. Thank you.
Yeah, and that's because our regulations don't talk about simulation at all. So that's just an education piece, because I know for years we've had a lot of the deans and directors talking about simulation and the board regulates simulation, and that's incorrect. So we just need to change that communication that we regulate direct patient care. And by addressing the direct patient care requirement, it opens up simulation for our deans and directors. So thank you for pointing that out. Anytime we get a chance to educate any of our stakeholders, that's perfect. So I appreciate that, Melda. Thank you.
Any other comments or questions? We need to open up to public comment.
We need a motion and a second before we open up to public comment.
So the motion would be to, and correct me if I'm wrong, because I want to get this right. Motion would be to begin the process of fulfilling the strategic plan, or to
let me help you out with that, Dolores. The motion would be to accept the action plan for the strategic plan, with any non-substantial changes to be approved by the administrative committee. And that would include updating the verbiage on, I believe it was 1.1. Let me just verify that number really quick.
2.1, I think.
2.1, sorry, on 2.1 to address that goal.
Okay, so I would like to make a motion to accept the action plan of the strategic plan without substantial changes. Is there anything I left out?
There is, with the Reza, can you help me out with that? I'm so sorry.
Sure.
That's okay.
So I think what you're trying to say is that the motion is to accept the action plan, including the amendments to be drafted to the success measure for item 2.1 to clarify that that has not been met, and also to incorporate the change proposed by Mary Fagan that the target date be met or exceeded, as well as, in addition, allowing staff to make any non-substantive changes, such as grammar and typos and things, with the final draft to be approved by the board's administrative committee.
I couldn't have said that better. That was perfect, Reza.
Said.
And you're just going to say ditto right now, right?
That's exactly what I'm saying. So I need a second.
This is Mary. I'll second.
Thank you, Mary.
Thank you.
Now we can open up to public comment.
Public comment now. I will be activating the question and answer feature. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Board President Trujillo, there are no public requests for comment. Would you like me to close this window?
I'm not able to hear you, Dolores. Are you muted?
Okay, so we have a motion on the floor and a second. So now we'll take it to a vote. Dolores Trujillo votes yes. Vice President Mary Fagan,
Mary Fagan votes yes.
Elizabeth Woods, Imelda Sejap Buckowitz,
Melda, yes.
Susan Anangho, and Jovita Dominguez.
Jovita votes yes.
Okay, motion carries. Thank you. All right, item 5.0, discussion and possible action regarding the board sunset report 2022. Lori?
Yes, so agenda item 5.0, just a little background. We did have our sunset hearing and our report just last year. So this process, we wrote our sunset report. It was brought in front of the board in December of 2020 and was approved and submitted to the legislator on January of 2021. We did our first sunset hearing, and then we had a second sunset hearing. And due to the newness of the executive team, due to all of the changes that were in process, the legislative personnel decided that it would be best to give us a 1-year extension, allow for us to just update our report instead of having to rewrite an entire report, and prove whether or not we were able to make the efficiencies and the progress that we promised we did in our sunset report and the hearings last year, with the expectation of getting a full 4-year extension. So what we've now been asked of is to update them with any changes. And so this report that is in front of you guys is a short and sweet kind of report. It is just updates. It does complement our full sunset report that was turned in a year ago. And it also complements the supplemental responses that we submitted for our second sunset hearing. So this is essentially a third report that is tied into our initial report. So hopefully I tried to explain that well. The sunset report from last year and the supplemental report is on our website for review. And included in the document here is the draft report to answer anything that has changed in just this last year. We do believe that this report will be received by the legislators and that we will have another hearing. The third hearing has not been set, and it hasn't even been promised that there would be a third hearing, but we are prepared for a third hearing if we are asked to attend one. In the sunset report in the draft, we would ask for a similar motion as the one that we just passed, where if there are, if the board has had a chance to review it and wants to accept the sunset report, that's fantastic. We'll move it forward. Understand that this report was written by our executive team, edited and approved by me, sent to legal counsel, Reza. He did some edits and improving, and then it was sent over to Department of Consumer Affairs, where Department of Consumer Affairs team evaluates it and provides input, and we've accepted those changes and are ready to submit a final report to the board. So it's gone through various layers of approval and edits and back and forth for you guys. If there are things that we missed, which is absolutely a possibility, or some point in there that you guys want us to address, in the motion that is requested is to state out what you would want addressed and then leave the final approval for non-substantial change to be up to the admin committee as well. Because this is due in January, we would like to get this moved through if at all possible. So I'm here for questions. Again, it is a smaller document. We did include updated licensing stats and enforcement stats, even though that was not requested by the legislators. But the other boards and bureaus who had to do updated reports very similar to us did include that. And so that was one of the recommendations from DCA. And it just shows good things for us. So continuing to make improvements. And if you guys have questions, I'm here.
Hi, this is Betty. Is there anything significant in this that's different?
All of these items, Betty, are updates and different from the previous report. We were asked to only report out changes and only to report out any process improvements and such. And so that is what we did. That's why it's a very abbreviated report.
Thank you.
Any questions or comments from the board? So we need a motion, correct, Lori? To accept this.
I have one question, if that's okay.
Yeah.
Yes.
On page 54, the joint continuing approval visit. Or it says page 50, page 54 of the whole, it's page 11 of, no, 12 of 26 of the actual sunset report. But just that joint continuing
Yes.
approval visit, I'm not sure what it means when it says that joint effort identified similarities but confirmed the vast differences between the accreditor's process utilizing an evaluation approach and the role of a regulator who serves as a consultant. I'm not sure exactly what that means.
I can expand on that. And it really started back with our initial sunset report. And in our initial sunset report, there were questions from the legislator on whether or not we could combine our continuing approval visits with accreditors, as the accreditors do a similar evaluation, was what the understanding was. And so with that, that was also part of our California state auditors, with part of the pre-licensure audit that we did. And they wanted us to look at that. It was one of the legislative recommendations that came through to have that evaluation. Instead of waiting for legislation to come through, which did not occur this past leg season, I brought it upon myself to do a work group with the deans and directors. And so October of 2020, we established a work group with 4 deans and directors that were complementary of private and community college, as well as ADN and BSN and programs that were already accredited and programs that were seeking accreditation. And we met every other week to kind of discuss some efficiencies. And based on recommendations from that subcommittee, we were able to schedule and hold our first combined continuing approval visit, which was with San Diego City College in the fall of this year. And it was wonderful to be able to attend that visit, because it was the first time that we were able to go as a nursing education consultant and see the accreditors in action. And we were both very complimentary of each other. There was not a singular function that the accreditors had or a singular function that the regulators had, the nursing education consultants being the regulators. And so what was discovered is those accrediting, they come in as an evaluator. They look at a snapshot right in time. They pull the information, say, do you meet it? Do you not meet it? And some of the things that came to light was the accreditors were looking at curriculum and they did not understand the individual curriculum. Well, the board does a curriculum form called an EDPP-05, and it's a total curriculum plan. And based on that, I was able to provide them with the EDPP-05 that the board uses to approve curriculum, and they were able to clear that school for appropriate curriculum. They were also looking through faculty preparation, continuing education. They were looking through to see if some of the qualifications were met. And they were not able to find everything that they needed. But then the board requires what's called an EDPP-10, a report on faculty. And I was able to present them with that, and they were able to then clear their requirements based on what we require as a board. And then there were items that needed improvement. And one of the lead evaluators actually said, I know you're in good hands with the Board of Registered Nursing. They serve as your consultant, and they will ensure that you reach this so that you'll be able to get accreditation. And so the way that NCSBN even looks at it is they have a comparison chart of what accreditation does and what the board approval does. And you can see that it's a symbiotic relationship, that it relies on each other to get to that full status. And so it was really clear at a frontline kind of viewpoint to be able to see the stark differences and really highlight how we work together, not in lieu of. And so that is what's highlighted here. And we have additionally moved all of the continuing approval visits to be in alignment with the accreditations process. We've also moved to accept the accreditations report and only ask for an addendum of the items that are different for the BRN. So this greatly decreases the work on the school. If the school has an 8-year visit or a 10-year visit with a 5-year interim report, we will align with that. We will not hold a separate BRN. We will have a separate BRN continuing approval visit if they are not accredited. But any of the schools that are accredited, we will align with their accrediting visit, and we will accept their reports and do the visit in conjunction with the accreditors, which is what other states do. And it's been received quite well by the first couple of schools that it's gone through.
Okay, so the plan definitely is to continue this going forward.
Absolutely. Yes, yes. Really working on getting those efficiencies and see how we can collaborate and work better together.
Perfect, great.
Any other questions or comments? So Lori, you need a motion to accept this final sunset report.
Yes, and since I didn't hear any edits, you can actually just make a motion to accept a report.
Yes. So I would like to make a motion to accept this. Is it the final sunset report?
Well, it wouldn't be final because, you know, sunsets happen on a routine basis.
So
We're praying for every 4 years. But I would like to also ask that, Dolores, that you include that if there is any non-substantial changes that need to be made, that the administrative committee can approve, just in case something does come up and we notice that somebody's name is spelled incorrectly. We don't have to pull a board meeting together and have to get that reapproved.
Sure.
So you could accept the sunset as written, and if there's any non-substantial changes, to have it approved by the admin committee prior to turning into the legislator.
Okay. I make a motion to accept the sunset report, including any non-substantive changes to be approved by the administrative committee.
Wood seconds.
Thank you. Let's open it up for public comment. BRN moderator.
The comment now. I will be activating the question and answer feature. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, I would like to make a comment. Board President Trujillo, there are no public requests for comment. Would you like me to close this window?
Yes, thank you. Okay, we have a motion on the floor with a second. Let's take it to a vote. Dolores Trujillo votes yes. Vice President Mary Fagan,
Mary Fagan, yes.
Elizabeth Woods,
Woods, yes.
Imelda Ceja Buckowitz, Susan Naranjo,
Susan, yes.
and Jovita Dominguez. Thank you. Motion carries. Moving on to item 6.0, discussion and possible action regarding scope of RN practice in relation to administration of medical cannabis in public schools and initiation of declaratory decision proceedings pursuant to Government Code Section 11465.10 et al.
Thank you. And this will actually be presented by Reza, our BRN legal counsel. Reza?
Reza.
So first off, let me ask our moderator to promote Michael Davis, who's in the list of attendees, to a panelist. And then while that happens, I'll go ahead and explain a bit about what this is about. For those board members who are on the Nursing Practice Committee, this is probably familiar to you to some extent, as this was discussed at our October board meeting. In the meeting materials, you should have seen a letter from a law firm. That letter was drafted by attorney Mike Davis, who's with us today in case you have any questions or would like him to speak. Mike's law firm represents public schools which have been kind of confronted with an interesting issue, and they've asked the BRN for some guidance. That issue has to do with whether or not school nurses, RNs who work for the school districts, can administer medical cannabis to students at the schools that have a valid doctor's recommendation. Typically, the types of conditions that benefit from medical cannabis are, for one example, severe seizure conditions, for which there's really not been any other medications that have been successful. So the issue that's come up, and this is an issue that I believe there was a specific student in that situation, but also it's an issue that is very likely to recur time and time again, perhaps even more frequently as medical cannabis kind of becomes more accepted as a treatment for those types of conditions. As I said, Mike's law firm has asked the board for clarification about whether RNs administering cannabis pursuant to a valid doctor's recommendation would be in violation of the Nursing Practice Act. The materials provide a lot of explanation about the facts and the law regarding both medical cannabis in California, as well as what's called an IEP, or an individualized education plan. And hopefully Mike will correct me if I'm wrong in any of this, but that letter from his law firm explained a lot of that information and the background of it. I also wanted to provide some kind of more general procedural law for your information. So up to this point so far, Mike's firm, as I said, requested guidance, and they did receive it in the form of an informal letter from a nursing education consultant, which is pretty typical when we get requests for scope of practice questions and things like that. Folks can receive an informal opinion from an NEC, which has been issued and which was in the meeting materials for you to see. But that opinion from the NEC is informal. It's not really meant to be legally binding. And so in order to provide kind of more formal clarification and something that RNs and the school districts out there can rely on more confidently, I wanted to talk to you about the option of doing what's called a declaratory decision and possibly giving it precedential effect. And I'll explain what that means. So a declaratory decision, it's kind of an interesting concept where an agency, a court or an administrative agency like the BRN has authority in a situation where there is an actual controversy, but where there hasn't been some actual harm or injury, where we have authority to issue a decision that essentially establishes the rights and obligations of the parties involved. A declaratory decision, so it's that there are laws in the Administrative Procedure Act and in the Office of Administrative Hearings regulations that kind of govern the procedure to do that. And it's important to follow that procedure and be mindful of it, because as you all know, when the board establishes any rule of general application that's ordinarily considered a, quote, regulation, and we have to go through the regulatory process by putting out draft regulatory text and receiving comment and having a waiting period and possibly a hearing, and then going through the Office of Administrative Law. That's to write regulations. A declaratory decision is not a regulation, but it does in a way establish a rule of general application. So in order to avoid that being kind of a method of sidestepping the regulatory process, there are specific procedures to follow, which include, an entity or an individual can write a request for a declaratory decision to an agency like the BRN. And if the board wants to consider doing a declaratory decision and providing the guidance that's requested, the process involves a few things. One, we give notice to any interested parties that we intend to do a declaratory decision, and those interested parties have an opportunity to submit comments. And you could decide, depending on the issue and what you feel is appropriate and worthwhile, you could decide to hold a hearing, and ultimately you would issue a decision that clarifies the statutes and or regulations within our area of jurisdiction. So that's really the point of it, is to clarify the application of our statutes and regulations. In this case, the clarification, again, that's sought is whether the scope of RN practice allows RNs to administer cannabis as needed pursuant to a physician's order and pursuant to an approved IEP that the school and the students' parents, I think it is, have established. So that's what a declaratory decision is. You can take it a step further if you'd like, by giving that decision what's called precedential effect. If you did not do that, if you just issue a declaratory decision, that would bind the parties who are part of that declaratory decision proceeding, which in this case would be Mike's law firm's clients who have made this request, and any other parties that may join that proceeding during the proceeding. Otherwise, it's not binding on other parties. However, if you were to give it precedential effect, that means that it is then binding on anyone that is out there. So I guess let me pause there and see if there's any questions about the procedure before we kind of dive into the substance of the discussion. Any questions about declaratory decisions or precedential effect?
So
If any
Reza,
come to,
yeah, if we decided we wanted to make a declaratory decision and decided not to do precedential effect, would that mean that there could potentially be many additional requests that would come forward similar to this that we would need to respond to?
conceivably, that could happen. Yeah. The idea of giving it precedential effect, I think, as you're kind of probably thinking about, is to address the issue for everyone that's out there. And really, one of the reasons for doing a declaratory decision is that this is an issue that's likely to recur time and again, and not just be kind of an isolated incident.
Is there any downside to having it have precedential effect?
Well, as I said, it's binding, so whatever it is, you've got to be confident in it. But I would, aside from that, I'd say not really, because you can always change that decision and withdraw the precedential effect.
And Mary, just for full transparency, at the beginning of this meeting at 12:57 p.m., I received an email from the same attorney's office adding another person onto the request for a declaratory decision. So when you asked, would they be kind of some multiple requests coming through, we've already received a second request in addition to this, just within the few months we've gone through this. So I do foresee that many more will be sought through this matter. Additionally, when talking with the supervising NEC, trying to get kind of an idea of how many times they get inquiries on this, it is a regular question. They didn't have specific count, but it is a regular question that comes across regarding administration of cannabis.
I think we need to look at this more broadly. This is not going to be the only person that comes with this request, because we know now that my understanding is that the parents have to go to school to administer the medication if the person needs it. So we're not in an isolated situation with cannabis.
Betty, can I ask you to come in closer to your mic? I'm having a really difficult time hearing you.
Do you hear me better?
I do. I hear you so much better. I think I caught what you were saying, is that parents right now need to come into school and administer.
My understanding now is the parents have to come in to administer the cannabis to the child if need be. And so I don't want to be doing something that only speaks to one individual, because this is not an individual issue. It is any children who are going to be under this same situation where they are using cannabis to control a number of things.
So I'm glad you mentioned that. That kind of gives me a chance to kind of talk about keeping this as a discrete issue. I agree, Betty. This there's a lot of issues surrounding this, and in general the issue of medical cannabis. Tons of issues there. There is, I think, separate legislation that was passed. I think it was SB 223 or 233, and Mike can speak to that if I got that wrong. But that's, I think, as you said, I think that's what passed a law that allowed parents to come onto campus and administer cannabis products to their kid if needed. So that's what you're, I think, speaking to, and I think that is a little bit separate and kind of unrelated to this, but it is in a sense related in that you know, that's the alternative, is that somebody's parent needs to come to the school and do it if the school nurse is not able or not willing to do it. Right now, aside from the parent doing it, the school nurses, I think they can do it, but it's ambiguous to them, or at least to some, it's uncertain whether it's within their scope of practice, whether they'd be potentially subject to discipline by the BRN. So really kind of the discrete issue that would be the subject of this declaratory decision proceeding is really just that. It's not dealing with parents coming in under that separate SB 223. I think it's really just dealing with the kind of narrow issue of the RN scope of practice, and can school nurses do it without violating our laws that we administer. And also, Betty, you mentioned at our last meeting a concern about nurse practitioners being able to, whether or not under AB 890, they can prescribe or make a recommendation for cannabis. And that's also kind of tying into what I wanted to say about just keeping this kind of to the discrete issue that's on the table. That's definitely a good point that you brought up then. And I think that there is some, you know, depending on who you ask, potentially some uncertainty there, because the statutes under AB 890 talk about the authority for NPs under 2837, 103, and 104 to, you know, prescribe, let me use the precise language. Bear with me. Yeah, plan and initiate a therapeutic regimen that includes ordering and prescribing non-pharmacological interventions, prescribe, administer, dispense, and furnish pharmacological agents. So those are the terms that are used in AB 890. On the other hand, the Compassionate Use Act, which is the set of legislation that initially in California set up the whole medical marijuana framework, speaks to an order of a physician specifically, and that hasn't been amended. So there may be some tension there, but really, despite kind of that tension between the Compassionate Use Act and the newer AB 890 as to that issue, I don't think that issue really kind of comes into play in this discussion, because really what we're talking about is, once there is a valid recommendation for medical cannabis, whether it be from a physician or, you know, for the sake of discussion right now, if an NP could do that, once there is a valid recommendation on file and the school has prepared one of these individualized education plans allowing the use of the cannabis product on campus, once all that is in place, can an RN assist with the administration? So the issue of how did we get to having a valid medical marijuana recommendation is kind of ancillary and outside the scope of this question that's been brought forth. It's really, once we have a valid recommendation on file, can an RN assist with that on campus? So that's all I had on that.
I'd just like to say one more thing about this whole issue. We have a child that has seizures, and cannabis helps that. Needs to be administered pretty quickly, not that a mother has to come in or somebody else has to come in. don't want children to be having a lot of seizures, and I think we need to keep that in mind. If there's a medication that works for them, they need to have it as soon as possible, because having many seizures is certainly not good for a child's mental health issues. And so,
And that brings up another thought that, there's, as I said, there's kind of a lot of laws at play here. One is the Nursing Practice Act that we deal with. There's the Compassionate Use Act that I mentioned that deals with, a physician being authorized to order medical marijuana. And then there's also I think it's federal law that governs the rights of students to receive what's called a fair and equivalent education, something like that, they're entitled to receive an equivalent education if accommodations can be made to allow that to happen. If a student is kind of shut out from participation in actually going to school in person because they can't get timely access to a medication that helps them, that may be an issue. And really what the school districts are looking for is, I think, being able to make that accommodation and get them that medicine timely so that the students can get that equivalent education without, unreasonable hurdles. So yeah, I wanted to just discuss if you were inclined to address this issue, kind of how it would play out going forwards. So Michael's law firm has submitted a request, and the initial question that hopefully we'll discuss and maybe decide today is this an issue that you're willing to take up as by way of a declaratory decision? I don't think that we're not going to make a decision today. We're not going to make a declaratory decision. We can get your pulse on what your feeling is initially, but ultimately, the question for you today is, do you want to go down that path of doing a declaratory decision? You can always deny the request and say, no, we're not going to take this issue up, and then it would kind of just leave the status quo. But if you wanted to take it up, that's the path forward. First off, answering, are we going to go down that path? And then, as I said, there would be a notice period where we provide any interested parties with notice of our intent to do a declaratory decision, and they would have an opportunity to write in or to request they be made a party or to request a hearing. So you'd receive a lot of public feedback to the extent that the public is interested in this issue. And then, and already Mike's law firm has put together, as is required in the regulations, a good faith list of the individuals and entities that they consider to be likely interested parties. Part of why you don't have that in front of you, it's really just largely on my fault and an issue of timing. As we got closer to the holidays, so we had that letter that's in your materials months ago, but there were more specific procedural requirements in regulation in order to request a declaratory decision. And that letter that you had back in October didn't check all of those boxes. And so as the holiday last week was approaching, I spoke to Mike and said, if you are intending to make a request for a declaratory decision, these are the additional things in regulation that need to be in your request. I didn't really give them a lot of time to update their letter, but we did receive it. And if you want to go down this path, that'll be presented to you. It's content-wise largely the same as what you've already got in front of you, just with the addition, like I said, of a list of potentially interested parties who we would notify that these proceedings are going forward. But yeah, you can also decide if you want to hold a hearing. It's not required that you hold a hearing on it, but at a future meeting is when you would, again, you can discuss it substantively today, but at a future meeting is when you'd really discuss it substantively and make a determination of what is your answer to this question. And then we would write up a declaratory decision for your approval, and that's kind of how it would play.
I think we need to move it along as quickly as possible. It's a patient care issue, it's a nursing practice issue. We have nurses doing it already. So I think we need to move this along for the declaratory decision.
I agree, Betty.
I agree too. Help me understand, Reza, why wouldn't we want it or be able to advance a declaratory decision today?
Because, as I said, one of the requirements is that we have to give notice to interested parties that we are intending to do a declaratory decision and give them an opportunity to write in. That's kind of similar, analogous in a way to the way that we have to, when we're doing regulations, notify the public that we're doing regulations and give them an opportunity to comment on it. But we haven't checked that box yet. So that's one of the procedural steps I think that definitely prohibits us from doing it today. And again, this was something that for those on the nursing practice committee, you're already kind of you got a preview of it and you discussed it in October, but we haven't discussed it with the full board. So that's why we kind of have to take it step by step.
So Reza, how many days as far as a notice to have a hearing? How many days would we, how far out are we looking at if we wanted to do a declaratory?
If you were going to hold a hearing, then we'd have to give notice to the public at least 45 days before the hearing. If you're not doing a hearing, you have to give notice to the public 45 days before you actually issue your decision, at least 45 days. So again, that mirrors the rulemaking process, 45 days.
Either way, it's 45 days.
Yeah, it's just whether it's from the date of the hearing or the date that you issue the declaratory decision.
Get some additional clarification there. If we were to hold a hearing at 45 days, but then we then have to do another 45 day in order to issue the declaratory statement?
I think the answer to that is no, if I understood it correctly. So if you were to hold a hearing, we would give notice to the public and to any potentially interested parties that we're going to hold a hearing. And then that hearing would take place more than 45 days from the date we gave that notice. And then at that hearing, you can determine what the outcome of this will be. And that's it as far as giving notice to the public.
I don't recall there being any public comment when we talked about it at the nursing practice committee meeting. So I'm not sure that a hearing is going to be necessary in terms of at least what I've heard from the public about wanting to have more dialogue about this.
It's legally, just procedurally, it's a step we can't really skip. I don't think we can consider, for example, the meeting agenda notice for that committee meeting or even this board meeting. I don't think we can consider that to be the notice that we gave pursuant to the statutes and regulations that govern this declaratory decision proceeding. At least, it might be a little bit of a stretch. So to kind of be, really abide by the technical formalities of it all, that's, I think, how we'd have to go about it. So and it may be that they're...
To do a hearing?
Sorry?
You're saying we do have to do a hearing?
You don't have to do a hearing, but you do have to do the 45-day notice.
Yeah, that's what I would recommend, is that we move forward with wanting to
notice.
Issue a declaratory statement. This would be the 45-day notice, and that this is within the scope of nursing practice. And I would recommend that we make it precedential. I don't know if that can be considered a motion or not if it's time.
So it certainly can. And what I think I heard you, let me just recap. Your suggestion, maybe your motion, would be to move forwards with the declaratory decision proceeding, to give notice to interested parties, to not plan on holding a hearing, and to plan on giving the whatever decision is reached precedential effect.
Yep.
Okay.
I'll second that.
And procedurally, Reza, if we were to notice, like say tomorrow, 45 days would put us mid-January. Does it have to come back to a board meeting, or do we move forward as is from there?
I think it would have to come back to a board meeting because, and let me just say as a separate aside, this is a probably, you all haven't heard of declaratory decisions, at least with the BRN, because it's not a proceeding that's often used. I don't know that the BRN has done one before, but I think you may decide today that you want to go forwards with it, and we may issue the notice, tomorrow and wait 45 days and may or may not get comments. But regardless, I think at the end of that period, the board is going to have to come back and actually discuss it and say, okay, this is our decision.
Okay, and we do have a practice committee scheduled in January that maybe I can give an update at. And then we do have a board meeting scheduled in February, and that would give us, with this being a mid-January date of ending the 45-day period, that would give us time for a 10-day posting period for the board meeting that is scheduled for the 16th of February. So if we do move on this quickly, it can line up where I can kind of give a report out to the nursing practice committee on the 13th, and then be ready for the board meeting February 16th.
So should we take that as a motion, Mary?
Motion.
Yep, that was my intent.
Yeah.
Okay, and then was it Betty that seconded it?
I heard Betty second it, but I'm not hearing Betty now.
I second it.
Excellent.
Can you hear me?
Okay. Yes. So we'll have to take public comment.
Yes.
Also, if you do have any questions, we've got Mike Davis, who wrote the letter on the list of panelists here. But unless you have any questions for Mike, we can turn it over to public comment on that motion.
Questions, comments from the board? Okay, let's open it up for public comment. BRN moderator, please open for public comment.
For public comment now, I will be activating the question and answer feature. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, I would like to make a comment. Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, I would like to make a comment.
This is Reza. While we wait for folks to potentially chime in, I just wanted to make sure that we've got the motion for the record. So Mary, Betty, please correct me if I'm wrong. As I understood it, the motion is to accept the request for a declaratory decision and move forwards with giving the 45-day notice without an intention to hold a hearing, and give the ultimate decision that's reached a precedential effect.
Couldn't have said it better myself.
Just wanted to make sure I got it. Thank you.
Sure.
Sherry Coburn would like to make a comment. 1 second, please. Go ahead. Hello.
Hi, this is Dr. Sherry Coburn. I am a member of the executive director of the California School Nurses Organization, and would like to thank the Board of Registered Nursing for taking up this issue. California School Nurses Organization is a professional school nurse organization, and as a primary healthcare professional in the K-12 system, we provide programs and services that enhance student health and well-being, and of course, student safety is our utmost concern. Unlike colleagues in the hospital, oftentimes school nurses have to make autonomous decisions and are charged with supervising others, such as unlicensed assistive personnel who, in the absence of a school nurse, have been delegated to by the physician to administer medical cannabis in this situation. And of course, we are concerned about that. With that being said, we hope that the Board of Registered Nursing looks at Title II, Section 49423 of the California Education Code that describes the employment of medical personnel that can assist with individuals with exceptional needs that require specialized healthcare services. These include a qualified person who possesses an appropriate credential, as well as qualified designated school personnel trained in the administration of specialized physical healthcare procedures, including medication administration. This procedure must be routine for the pupil, pose little harm for the pupil, performed with predictable outcomes, and does not require a nursing assessment, interpretation, or decision-making by the designated school personnel. Additionally, when medication is ordered in the educational setting, we would ask that Title II and Section 49423 please be followed by both registered nurses as well as unlicensed assistive personnel, which require a prescription. I know that Mr. Davis had addressed that medication may include not only substances dispensed in the United States by a prescription, but also substances that does not require prescription, such as over-the-counter remedies, nutritional supplements, and herbal remedies. But it does still require prescription by a physician or a healthcare provider, authorized healthcare provider in the educational setting. And what must be noted is the pupil's name, the name of the medication the pupil is required to take, the dosage of the medication, the method by which the pupil is required to take the medication, the time the medication is to be taken throughout the day, the date on which the pupil is required to take the medication, and the authorized healthcare provider's name and contact information, as well as the parent's consent in allowing the administration of such medication. Thank you so much for your consideration of this request.
Ms. Coburn, this is the board counsel. Just wanted to make sure I got your citation. That was California Code of Regulations, Title II, was it section 49423?
Well, it's in the California Education Code 49423.5.
Oh, education.
Yeah, and then also in Title II, Section 601 of the California Code of Regs.
That was Title II, California Code of Regulations.
Yes, Section 601.
Okay, and I heard a portion of your request to be regarding clarification as to not only registered nurses, but also unlicensed personnel. And I just wanted to say, I don't know that we have any jurisdiction over unlicensed personnel. We can only speak to the scope of practice of RNs.
Right. Yes, and I recognize that. Thank you so much. However, there are school nursing shortages as well. And oftentimes unlicensed assistive personnel are asked or designated by the prescribing physician to administer this medication to children. So I just want the board to be fully cognizant that it may not be a school nurse administering the medication, more likely in the supervisorial capacity. Does that make sense?
Thank you. I think I understand. Yes, thank you.
And I'm sorry, I want to clarify Title V, Section 601. Excuse me.
Thank you for that.
Thank you. Lydia Bourne would like to make a comment. 1 second, please. Go ahead. Yes, go ahead.
Okay, fine. Thank you. I am Lydia Warren, the legislative advocate for the California School Nurses Organization. This is a issue that has been heard twice, once before the board and once before the Nurse Practice Act. And in both instances, we sent in a letter voicing our concerns about what we believe may be the direction that the BRN is taking on this issue. Yes, the BRN, our potential school nurses are certainly licensed under the BRN, but the education code also dictates the function, the role, and responsibilities of school nurses. And looking at these two cases, it does not appear that the education code has been reviewed in terms of how the school nurse, and that's how it was called a school nurse, when in fact it was actually an LVN under an IEP, was administering the medical cannabis for this particular child, for these two children. So there are a couple of issues I think that need to be looked at. One is there are three different situations here. One is an IEP, which obviously is dictated by the federal law, the Individuals with Disabilities Act. And these two situations fall under that, and the LVN has been hired in order to administer. Secondly, would be rescue medications. That would be if a child is having unintended or unexpected epilepsy occurrence, then almost anybody in the school would react, because this would be essentially trying to prevent any further untoward events. And then, of course, the maintenance dose, which again would be administered. The education code very clearly says that, first of all, the school district has to put in place a policy that would allow a parent to come onto the school grounds to administer this. And I think your lawyer has already kind of spoken to that issue. So number one, you have to have that policy. Secondly, the education code states that no school staff is required to administer the medical marijuana, irrespective of whether there is a physician's order. And of course, there always is a physician's order. And so I think that has to be taken into concern. You're using the term school nurses, but LVNs cannot ever be called school nurses in California. Again, if you want, you would take a look at the education code in terms of the requirements for a school nurse, that a person is designated as a school nurse, as well as the Commission on Teacher Credentialing. And so I think that those are some critical issues that need to be looked at as you move forward in terms of making any type of you call it the declaratory statement about medical cannabis in the schools. The education code, I think, provides that that direction that at this point in time, in terms of the conversations that I've heard, is not being looked at. Thank you.
Thank you. Dana Adams would like to make a comment. 1 second, please. Go ahead.
My daughter, Brooke Adams, won the case in California to have cannabis at her school. And it is administered by an LVN, but I've been working with others, and Joan, she had submitted a comment and wanted to make sure that I had addressed it here. Joan Idleston. She says she had another meeting, but she wanted to point out that the California Supreme Court in Anna versus Torkelson, 2013, noted that school districts are responsible for providing care during the school day and cannot place a burden on parents to come in to care for their children. Students are legitimately being ordered medical cannabis by providers at healthcare systems such as UCSF and UCLA in order for them to attend school by having their chronic medical conditions seizures, etc., adequately controlled. School nurses should be able to administer or assist students with ordered medication, especially in emergencies, or to train UAPs as well. The BRN should make clear that nurses are supported in following medical orders for students who require medical cannabis during the school day. I know that other children are wanting to be able to take cannabis at school to help with seizures or autism or other behaviors. And it's very difficult for parents to come to the school to administer it. And in our case, Dr. Sullivan had noted in his declaration that in order to give cannabis, it does not have to be a nurse. It can be someone that's trained in the process, just like other medications. Also, because cannabis is on a federal restriction, Schedule 1 of narcotics, until it's completely removed, it would have to be a prescription, which you can't give at this point because it's on the list. So I know there's a lot of uncertainty and unclarity about being able to get a prescription. Epidiolex has been removed from the schedules completely. Thank you.
Thank you. Board President Trujillo, there are no other public requests for comment. Would you like me to close this window?
Yes, close the window. Before we take it to a vote, I have a quick question. Is Mr. Davis still elevated to panelists?
Yes, yes.
Okay. So my question, and Mr. Davis, and I don't know if you really have the answer or you don't. As part of the physician plan of care, is there a set concentration that the nurses are looking at from wherever the parents are obtaining the cannabis from? Is there a concentration that is used or recommended, or I'm just wondering if the nurses realize really how much they're giving when they're giving it. That's all.
Mr. Rio, for that question, and it's a very important question. As some of I believe Ms. Coburn may have stated on the line, citing to Education Code 49423, the school districts are required to obtain a parent statement and a physician statement prior to administering any medication, and the intended dose, route, all of that information needs to be provided to the school in order to administer any medication. So that information is going to be gathered. An issue, and this is why I think is one of the reasons why Department of Cannabis Control is on the list of interested parties, is determining whether the medication that's provided to the school or the nurse is in fact what's been recommended by a physician and included in a care plan. For example, if you purchase a tincture from a licensed dispensary or retailer in the state, it will come with a little sticker on it that shows the lab result test of cannabinoid content. So if you have a child who is supposed to be taking a 10-to-1 CBD to THC ratio oil, you'll be able to look at that label and determine, okay, there's 100 parts cannabidiol and 10 parts THC. We have our 10-to-1 ratio, and then it's about administering the amount that has been recommended by the physician in the plan. So absolutely, I think one of the primary concerns and one of the issues that we're working through with our nurse and have worked through is to have the recommendation from the physician match with the medication that's being provided by the parents, because the parents have to provide it. And there is, there are the two routes that it can come. It can come, possibly from the retailer, or there's the long history in California of non-retailer provided product. And in the current legislation, there's an avenue for products to be tested by a licensed laboratory and be able to provide that same level of confidence in the the content of the product, as well as the presence of any toxins, heavy metals, et cetera, which are all part of the normal retail supply chain testing. Does that answer the question?
Yes, thank you.
Okay, thank you.
Any other questions or comments from the board? Okay, we have a motion on the floor. We have a second. We can take it to a vote. Dolores Trujillo votes yes. Vice President Mary Fagan.
Mary Fagan, yes.
Elizabeth Woods.
Woods, yes.
Imelda Seja Buckowitz. Imelda. Okay, we'll come back to her. Susan Naranjo. Ovita Dominguez.
Jovita votes yes.
Imelda Seja Buckowitz.
I vote yes.
Okay, motion carries. Thank you. And thank you, Mr. Davis. All right, moving on to the next agenda item, item 7.0, discussion and possible action regarding fees to be collected pursuant to Business and Professions Code, Section 2837.104, Subdivision B2, for possible implementation in California Code of Regulations, Title 16, proposed Section 1482.4, and lack of authority regarding fees under BPC, Section 2837.103. Is this you, Lori?
It is. I will be tag teaming it though. Board moderator, can you elevate Heather Hoganson, please? And while he's elevating, Reza is available to assist with this as well. With the passing of AB 890, we've been working with the Nurse Practitioner Advisory Committee and going through the different steps to get the 103 NPs up and going, as well as the 104 NPs. Part of that is to issue certifications through our licensing department to delineate out to the public and the employers which NP has the ability to do what. As we're aware of, a nurse practitioner, when they graduate from school, must operate under the assistance of a physician and work under standardized procedures for the first 3 years. And then second to those 3 years, once they've completed the 4,600 hours and the transition to practice, they can move in, work within a group setting without standardized procedures. And then 3 more years later, they can then graduate to private practice without requiring standardized procedures and working underneath a physician, but having a referral plan. That is a licensing process through our board. And in the passing of AB 890, it gave us the statutory authority to put a fee to the 104 NP. It missed and did not give us a statutory authority for putting a fee to the 103 NP. So we wanted to bring that information to the board here. That would, one, allow us to establish a fee for the 104 NP, as well as seeking some legislative movement to get that authority to establish a fee for the 103 NP. And I will turn that over to Heather so she can add to it. Yes, we can.
Great. So yeah, as Lori summed up very adequately, in order to charge a fee, you will need authority. So that would have to be fixed legislatively. And then in order to set that fee in regulation, you would need to do a detailed analysis of what that fee might be. Do you have any questions?
How will the fee be used?
So the fee is our fund, Betty. So all of the fees that we collect go to the board fund and are used to manage our board. We are Special Fund Board, we do not receive any payment from the state. And so our entire board is run by that. We do fee studies, we do desk audits, and that tells us what the fees should be. And that's what we go through that process to delineate the personnel that's required, the time that is required, the steps that are required for evaluation, and then of course making it the moves within Breeze, and then having that show out on the public side of Breeze so that our stakeholders would know. This would also be where we would then delineate on the license lookup page the type of nurse practitioner, and some of the language that's kind of going out is the independent nurse practitioner within a group setting would be the 103 NP, or the independent group nurse practitioner private practice, which would maybe be the 104 NP, but really making that clear to whoever is receiving service or working with that NP so that they know what the scope of practice is for that specific NP and whether or not they've created and not created, but followed that pathway to independent practice.
It just goes into the regular fee.
What was that, Betty? Can you come closer to the speakers? I'm so sorry.
Yeah, okay. So it just goes into the regular fund.
Yeah, it goes into our fund, the special fund, not a general fund. It's the BRN fund.
No, I understand that.
Yeah. Just like we would, so we collect $100 for anybody that applies for an interim permit. We collect $100 for anybody that applies for a temporary license. And so it would be that similar process that if you're applying for this, we would take a fee and then process your application.
Thanks.
And just to add on really quickly, the idea is by charging a fee to process the application, and you're just charging what the state is expending to process it, rather than having all of the licensees bear the general burden. It's the person who wants the new certificate, the new registration, the new permit. They're the ones that are paying that specific fee for the work done.
But it would be a one-time fee, it's not annual.
This would be for an initial fee. Whether or not there's a renewal fee increase or something that would need to go in to people that have a 103 or a 104, that would remain to be seen.
Thank you.
A renewal cycle is every 2 years. And so that would, if we sought legislation for the 103 NP, we would include that. But I believe right now in the bill text itself, I had it pulled up here, I'm sorry. It just says the bill would require the board to issue that certification to a nurse practitioner who meets additional specified education and experience requirements, and would authorize the board to charge a fee for the cost of issuing the certificates. Additionally, when it goes down further in the specific language, it says the board may charge a fee in an amount sufficient to cover the reasonable regulatory cost of issuing the certificate. So right now it's not clear that includes renewals. So that again would be something that we would have to look at. Did you interpret that anything differently, Heather?
No, you're spot on.
So just to be clear, when a nurse practitioner applies for their initial license in California, there is a fee, correct?
Correct. Any NP that's either coming into California or was educated in California as a new grad does apply for a nurse practitioner certification. What that nurse practitioner certification does is it goes off of the RN license and allows the nurse practitioner to work with a physician under standardized procedures.
And that's pretty much the same as the 103, right?
That is not the same as a 103. The 103 NP comes in 3 years after they have started work as a nurse practitioner, or 4,600 hours. It's equivalent full time. And that NP needs to complete the transition to practice, and then they would work without standardized procedures within a group setting or like a hospital setting like Kaiser or something that where they work with other healthcare providers. But they are not required to be under a physician at that point, and they are not required to use standardized procedures. They are required to work within a healthcare group so that they have consultation readily available. And then the 104 is they can go into private practice.
So there'd be 4 levels or 3 levels of fees for nurse practitioners, whereas right now there's 1.
There is 1 level of fee right now for a nurse practitioner. What this statute sets is for the 104 NP, they would have to pay for the initial certification as a 104. We do not currently have the authority for to charge a fee for the 103 NP. That was a miss in the bill or didn't align with our process. I'm not sure how you want to kind of label that, but it was not included in the bill for a 103 when that bill was passed. So for it to be equitable, you would charge for a 103, so we would have to seek legislation for that. And then you would make that same charge for the 104. Now that is only for initial certification as a 103 or initial certification as a 104. That renewal would just be the renewal of the NP. I don't know that there would be any reason why we would have to do a separate renewal for those various NP certifications. Right now, they fall underneath the categories of NPs. And there are several categories of NP, psych mental health NP, pediatric nurse practitioner, neonatal nurse practitioner, and you can renew your NP with those various certifications that you may have, and you don't have to pay additionally for each one. You would just pay for your renewal as an NP, but you do pay for that initial.
Mary, this is Betty. Right now, nurse practitioners pay the fee for RN, and then there's an additional fee for the nurse practitioner. So there's 2 fees that nurse practitioners pay right now.
And that's that's for the certification as an NP. And then this would add, if they wanted to do the 103, everyone's going to have to eventually do the 103 though, right, Lori?
No, you can stay in a regular NP and choose to work with a physician under standardized procedures indefinitely.
Okay.
You do not have to take the pathway to independent practice unless you choose so. And you can go to be a 103 NP, and you can even stop at that and just work within a group setting indefinitely. You do not need to even pursue the final one to private practice as a 104 NP if they do not choose so. So there would be 3 different primary categories of an NP within California.
Okay, so nothing would need to change from what NPs pay now unless they choose to go to the 103 or then later.
That is correct. Nothing will change with our initial NP licensure certification that is based on our RN licensure.
And how are the fees typically determined, what an appropriate fee is?
There are 2 different ways that they're typically done, and one is a desk audit, and that is the one that we are looking at pursuing for the 104 NP. And because we have very similar processes that we're already doing, and so they would just do a desk audit and say, okay, that's similar and it's the same fee across the board. There is also another way that if it's a new process, there was nothing else that we can compare it to, we would do a fee study. And we would have a company come in and take a look at what is all required, compare it, and draw some comparisons through, and then we would present that to the board. That is not needed, as this is a very similar process with just a couple modifiers that have to happen. And so my just kind of basic thought process would be that this would be a minimal fee, and it is very similar to the processes that we already have defined. And so a desk audit would be appropriate for the 104. We do still need to seek legislation for the 103.
Correct me. I just want to make sure I have this right. So we are looking to establish a fee for the initial certification for the 104 NP?
Correct. That's the one that we have statutory authority of right now.
Okay. And then what about
We
the,
need to get legislation
okay,
to support the board to have authority in getting the 103 NP certification. So it would be a motion to establish the fee through a desk audit for the 104 and to seek legislative support to get that same authority through for the 103. And Heather may have some real spiffy legal jargon that needs to be stated on the motion if that's what you're looking for. And Dolores nodded. I'm not sure if you saw that, Heather. So if Dolores is looking for some motion language that needs to be done for this.
Well, if the motion is to, direct the executive officer to pursue a legislative amendment to permit the board to implement a fee for the 103s, that would be one motion. And then possibly you might want to do it as a separate motion to direct the executive officer to, conduct the appropriate fee study and bring the results back to you. And I guess you don't even need to do this because then Lori could bring the results back to you of what that is. And then at that point, we would have some regulatory language that would go along with it. And that would be to put a fee into regulation, once that fee has been determined. And that would just be a regulatory action for you separately.
so the second one, do you need a motion for that, or can Lori do the study and bring it back to the board?
I'll defer to Reza, but I think you can just tell her to do the study and then let you know, and then you can make that decision later. But for the first one, I believe she would need some direction to pursue that legislative pathway. But I'll defer to Reza on that.
I would agree that to seek legislation, we would need a motion. But for Lori to conduct the desk audit, that's really something that the board staff are just going to do, working with folks at DCA in the budgets office, and just putting together an estimation. Really what that involves is an assessment of, okay, the process of receiving this application and processing it consists of this classification of worker, spending this number of hours, doing this task, and for each of the tasks that are required to come up with a figure of what it roughly costs the board in terms of staff time and expense to process that application. I don't think you need a motion necessarily to do that. Ultimately, the results of that will be brought back to you, and we'd need a motion to approve the dollar amount as the fee that will be put in regulation. But of course, I don't think we have that yet. So.
Right, and when we do bring that back to you, we'll have a nice little motion language with a bow on it for you.
Thank you.
As for the 103 fee, I'll just say, for background information and clarification, we've gotten a handful of public comments here and there saying that they've been across the board, they've been varied, and as I've said all along, they've been across the entire spectrum, and many of them kind of go in opposite directions. But one of the kind of stakeholder groups has been saying there shouldn't be an application process to become a 103. You should just fulfill the requirements and automatically be a 103 without having to do anything involving the Board of Registered Nursing. I'm not sure that the board has really, the board has certainly heard that comment and that concern. I'm not sure that it really has taken that as a feasible route to go. Looking at the language of 103, it's hard to imagine a process by which someone would automatically be considered a 103 and be let loose to go practice without standardized procedures independently. Just as one single example, the language of 103 says that one of the requirements to become a 103 is that the NP has to provide documentation that educational training was consistent with standards established by the board, et cetera. And that's at 2837.103A1C. And there's, in general, the requirements there, looking at that requirement specifically, provide documentation to who? It obviously implies that they have to provide documentation to the board, and it takes time for board staff to review the documentation and determine that the educational training was in fact consistent with the board standards. So I just wanted to acknowledge the fact that we have gotten those comments that there shouldn't be an application process at all for 103. But in my opinion, I don't see a workable way of doing that. It seems kind of inevitable that there has to be some process to become designated as a 103 NP. And so with that comes the kind of administrative work that the board has to do. And as it stands right now, that administrative work is going to be, frankly, at a loss to the board because we don't have the fee authority. So in order to recoup those costs, just like we do for every other type of license or certification, there probably ought to be a fee there as well. And I understand the concerns about fees on top of fees, but it just comes down to the fact that there is an administrative burden in processing those things, and where ought that cost be properly allocated, it's probably best that it be the individual that's applying. So I just wanted to, and that may kind of be why, well, anyways, I just wanted to acknowledge that comment and part of why it may be necessary to address that issue.
Any other comments or questions from the board? All right, so I'm going to take a stab at this motion. So I would like to make a motion to direct the EO to seek legislation to establish a fee for the 104 NP. Did I get everything in there?
Almost.
I think you mean 103 NP.
And 103 NP, sorry, 103.
And to be clear, it's not part of the motion. It's not a necessary part of the motion. Under 104, Lori is going to just go ahead and continue or initiate the desk audit, which will be presented to you at a later time.
This is Betty. There's still that question in my mind. Are these fees going to be one-time fee, or is it going to be every 2 years when people are renewing their license?
The statutory authority that we have right now is for initial. We do not have any authority for renewal, so it would be a one-time fee.
Right? 103 or 104?
We don't have a statutory authority for 103, but we would seek similar. So it would be one to one if we're able to get the legislation to support that.
Did that answer your question sufficiently, Betty?
For now.
No.
Yes, for now.
Yes, thank you. Okay, do I have a second?
Ocean emailed us, they have that go.
Thank you, Imelda. BRN moderator, can we open for public comment?
We will be opening for public comment now. I will be activating the question and answer feature. Please refer to the screen share for members of the public to see how they should type in the request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Dr. Cynthia Yovanov would like to make a comment. 1 second, please. Go ahead.
Hear me?
Yes.
Oh,
Go ahead.
perfect. Good afternoon, everybody. Kind of tagged in on the latter half of the meeting. Thank you for taking my comment. I do understand that this can be an administrative burden, you know, trying to move the 103s and the 104s. I would like to recommend that the fees are only a one-time, not recurrent. But my biggest concern has always been, with all due respect to Riza, who I know your role is to really support the BRN, but you know, the conversation appears to be very biased when you are delivering to the public, including myself, when you just stated that documentation would be needed to, in quotations, let loose the nurse practitioners. I kind of find it very personal because we have worked very hard as nurse practitioners in California to provide access to our patients. And those comments that are very biased and it comes from opposition to nurse practitioners, it confirms that you don't stay neutral. And I'm hoping that you take it into consideration without, you know, without feeling attacked, but telling nurse practitioners that a document is needed to be let loose to the public is actually very negative representation for us. So I'm just asking that you have your comments stay neutral and not geared or sided to opposition of nurse practitioners, because that's been the comments throughout every single meeting that I've been on, and it's getting worse and worse. So I would ask that you respect the services that we are trying to do for the community, for our patients, because this has been an ongoing struggle and the community needs us. So thank you, board, for listening to all the comments and, you know, taking my comments every time I'm on this meeting. Thanks.
Briefly, since it was directed to me, if I may. I apologize for the implication from the terminology I used. Let loose was not intended to be derogatory in any way or to imply something negative. I'm not sure that that is the only possible interpretation of the phrasing that I used, but if you took it a certain kind of negative way, I apologize. I frankly don't really have any bias or any subjective reason to be opposed to NPs. In fact, I very much value the work that our licensees do, and my only objective here has been to ensure that this board follows the law and implements the law and does everything above board and by the book. So I will try to consider your comments in the future, and I apologize again if you have misinterpreted my intent in anything that I've said.
Thank you. Board President Trujillo, there are no other public requests for comment. Would you like me to close this window?
Yes, thank you. Okay, we have a motion on the floor and a second. So we'll take it to a vote. Dolores Trujillo votes yes. Vice President Mary Fagan,
Mary Fagan, yes.
Elizabeth Woods, Imelda Seja Bukowitz,
Melda, yes.
Susan Naranjo, and Jovita Dominguez.
Jovita, yes.
Thank you. All right. I believe our next item is to adjourn. Thank you, everyone, for participating in today's board meeting. And have a wonderful holiday.
Same to you.
Thank you.